Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those here in Carson City, as well as anyone who may be watching online. With that, Committee Secretary, will you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine. Assemblywoman Gallant. Here. Assemblyman Gray. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman LaRue Hatch. Here. Assemblywoman Marzola.
Here.
Assemblywoman Mosca. Assemblywoman Newby. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here. And I believe everyone is here. So with that, we'll go ahead and get started. Just a few housekeeping notes. Please, again, make sure you turn down anything on your electronics to make sure we don't have any disruption during the hearing. We will have public comment at the end. And just a reminder to everyone, as we're getting back in the swing of daily hearings, to please make sure, as anything you're preparing for your presentation, that you get it into us by noon the day before. With that, we will go ahead and get started. We have two bills on our agenda today, but we are going to take them out of order. So we will actually start with Senate Bill 37, which will be presented, I understand, by the Attorney General's Chief of Staff, Ms. Benitez Thompson. No, not presented. Okay. Then presented by Nathan Holland, Deputy Attorney General of Government and Natural Resources Division. And SB 37 authorizes governmental attorneys to volunteer as third-party neutral mediators under certain circumstances. So, Mr. Holland, please. I will open the hearing on SB 37. And is Ms. Pirro also on this one, or you're doing SB 37 alone? SB 37 alone, okay. Please proceed when you're ready.
Assemblywoman Miller, members of the Assembly Judiciary Committee, thank you for the opportunity to testify in support of Senate Bill 37. For the record, my name is Nathan Holland. I am a Deputy Attorney General in the Government and Natural Resources Division. SB 37 is a proposed revision to Chapter 7 of the Nevada Revised Statute that would expand access to volunteer mediation services and provide additional avenues for attorneys in public service to volunteer their time to benefit their communities. Before I explain the bill, I'd like to briefly explain how the idea for this statutory change came about. Attorney General Ford frequently reminds the Office of the Attorney General that our job is justice. He describes his office priorities as the 5 C's, one of which is community engagement. The other 4 are constitutional rights, criminal justice reform, consumer protection, and client services. As a Deputy Attorney General in the office, my practice includes representation of the Labor Relations Unit, which engages in collective bargaining with designated representatives of state employees. I have experience and interest resolving disputes through cooperative mediation and negotiations. My passion for negotiation and Attorney General Ford's commitment to community engagement invoked me to consider ways I could use my skills and my free time to benefit the community. Sometime last year, I began looking into volunteering my time with local community organizations that assist people in resolving their differences amicably. Unfortunately, I learned that the existing law that allowed public attorneys to volunteer to represent indigent persons in pro bono services, NRS 7.065, did not allow for us to serve as neutral mediators. Thankfully, Attorney General Ford encourages his attorneys to bring forward ideas for bill drafts. The office approved my request to amend this section to allow public sector employees to serve as volunteer mediators. Existing law allows any attorney employed by the state of Nevada or any agency or political subdivision of the state to volunteer their time to represent indigent persons in court, but does not allow them to volunteer their time as third-party neutral mediators. SB 37 would add subsection 2 to NRS 7.065 to allow service as third-party neutral mediators as long as certain conditions were met. These five conditions mirror the existing four conditions currently placed on attorneys who volunteer to represent indigent persons, and adds a requirement to both sections that attorneys' efforts must comply with the Nevada rules of professional conduct at all time. The five common sense restrictions on volunteering are as follows. First, the employer of the attorneys must be aware of and have the opportunity to object to the representation, so the bill requires the attorney seeking to volunteer as a mediator to first receive permission from his or her supervisor, if any, to serve as a third-party neutral mediator in each dispute or matter. Second, the employer and the mediating parties must be confident that the attorney is free from any bias or outside interests in both their day job and their volunteer work. So the interests of the mediating parties must not conflict with the interests of the attorney's employer. Third, this must be true community service to assist those unable to pay for mediation services. So the services and mediators are provided through or in association with an organization that provides free mediation services to individuals. Fourth, this must be a true volunteer opportunity and not a way to supplement the attorney's income. So the attorney must not receive any compensation for the service. Fifth and finally, the service as a mediator must meet all existing ethical obligations contained in the Nevada rules of professional conduct. So the attorney assures that they will confine themselves to the ethical rules that govern every lawyer's conduct. This BDR also proposes to add the requirement that his or her professional conduct comply with the provisions of the Nevada rules of professional conduct to the ability to volunteer their time as a pro bono attorney to indigent persons in subsection 1 of NRS 7.065. However, attorneys volunteering to serve as pro bono attorneys were already required to conform to the Nevada rules of professional conduct. So this addition is only added in consistency with the new subsection 2. This concludes the proposed changes contained in SB 37. In closing, SB 37 makes one small but important change with many community benefits. This BDR allows attorneys employed by public employers to serve as third-party neutral mediators in certain circumstances. This expands the pool of volunteer mediators available to assist organizations providing no-cost mediation services, which increases access to volunteer mediators for individuals seeking to resolve their differences amicably. This also assists our communities in developing skills to resolve their differences outside the court of law, which should decrease the number of cases that are needed to be resolved by judges and justices across the state. I'm thankful that the Attorney General has brought this bill forward and allowed me to present it to you today. I'm excited to be the first to volunteer my time once it becomes law. I'm even more excited to start recruiting other public service employees to help our communities resolve their differences cooperatively whenever possible. Thank you for your time and listening to my presentation today. I welcome any questions that you may have.
Thank you for your presentation, and we're excited for you too, but I understand you have to get permission first from your boss, so hopefully he grants that to you.
Fingers crossed.
With that, we do have a few questions. We will start with Assemblyman Urick.
Thank you, Chair. Really thank you for bringing this bill. I think it's great to see somebody with a heart to serve like that, and I love the fact that the Attorney General is encouraging people to bring bill draft requests, and this is a great idea. My question actually ties into what Chair just said. You have to get permission from your supervisor, which I think is a great idea, but it says, if any. Are there people that work in the AG's office that don't have supervisors, and if so, what happens in that case?
So that provision was basically just for Mr. Ford so that he could volunteer as a mediator if he would like to. But yes, pretty much all of us have someone up the chain until you get to AG Ford. This is Nathan Holland for the record.
Our next question is from Assemblyman Orenlicker.
Thank you, Chair, and thank you for bringing this bill. I really appreciate what this will accomplish. My one question, I just want to be sure, is with the provision about that it has to be for an organization that provides free mediation services, which isn't exactly the same as saying with the defense to indigent defendants. So are there now or might there be organizations that provide free mediation services that aren't tied to the participant's income, so that we might be providing your services to non-indigent people who need mediation?
Nathan Allen for the record. That's a very good question. And yes, the indigency clause is only applied to subsection 1 and it is not applied to subsection 2. And the reason for that, thought behind that, was that we didn't want to put an additional burden on the the organizations that provide free mediation services to have to qualify the people seeking for free mediation as indigent. They already go through a process, and we do have somebody who is with one of the neighborhood mediation programs here to speak on behalf of, and could answer questions on that behalf. But yes, it is possible that we will be volunteering our time, we could volunteer our time to somebody who wasn't indigent and just was seeking free mediation services. But the vast majority of people the vast majority of people, my understanding is the vast majority of people who are seeking free mediation services through these organizations are not affluent.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair. Good morning, and thank you for being here. Sounds like a fabulous idea. Could you give us a real-life anecdote, like, so we can see how this looks? What would be a mediation scenario that this would apply to, that maybe you would be involved in?
So a lot of the people seeking free mediation services are dealing with neighbor disputes, barking dogs, loud neighbors, people parking in their parking spot, things along those lines. I actually just attended a mediation training put on by the National Judicial College, and there were multiple judges there, some from small claims courts, and they actually said that if they worry most about getting shot in the parking lot from a barking dog case, just because those get so heated. And the Neighborhood Mediation Center and the other mediation centers do work with those. In addition to those, they work with foreclosures, possibly evictions, things along those lines, mechanics liens, stuff like that. Mostly small claims court issues.
Thank you for that. We have a question from Assemblywoman Cohen.
Thank you, Chair, and I echo my colleagues. Thank you for bringing this forward. My question is about the conflict check. I know that that's the same that you have in the existing statute, but can you tell us a little bit about that? Because as we know, the Attorney General's office is really large, and we know that we've got a lot of state agencies, so how is the conflicts check accomplished?
Nathan Allen for the record. Thank you for the question. So whenever we request from our supervisor to mediate, we have to inform the supervisor what the issues are that are going to be mediated, and then the supervisor would be checking up the chain to see if there's any conflict. For instance, one of the mediation programs that the AG's office is involved in is actually mediating disputes for inmate civil rights cases, and they're always seeking mediators in those cases. But unfortunately, the AG's office couldn't volunteer to mediate any of those cases because we're involved as one of the parties in that. So that's one where there would be a conflict. And I'm sure that there's dozens of different conflicts that I just am not being able to pull off the top of my head. But it would go up the chain whenever you request from your supervisor. The supervisor would be made aware of what the issues are that are being negotiated and being mediated, and then they will see if there's any conflict within the office.
So I have a question in the other direction with this. So I see the parameters that protect the agency and protect your license to practice, to make sure there's no conflict, and that we're getting permission from our employer. But is there any support for you as the attorney that you want to do something, like say for instance, an instance where, of course, we all understand a conflict of interest case, but what if your employer just simply says, no, I don't want you to do it, you don't have the time? I don't like them, I don't, like, can it just be that arbitrary where they just make the decision no, just based on being your supervisor?
This is Nathan Holland. Thank you for the question. So this is a volunteer opportunity that will be taken on our own time. So it won't be taking a time away from our employers. So it's just pro bono work, the hours that we put in our free time. So that wouldn't be an issue as if they said that we don't have time to take the job or take the mediation, because it wouldn't be taking time away from our normal 8 to 5 duties.
You have normal 8 to 5 duties?
No.
I'm like, where are we at? But okay.
No, we don't. But to be honest with you, every supervisor that I've had at the AG's office has just been absolutely fantastic to work with. My current team chief, Greg Ott, is the best boss I've ever had, and I could not imagine that he would ever have any objections. That
Sir, you just have to get us to vote for it. Not
fair enough. But
doing the most right now.
But yes, that's not necessarily a concern. And also, if you think about it, the being able to mediate a dispute is a very limited amount of time. It's not like where you're volunteering to represent somebody in a case where you have to do a bunch of work to try to familiarize yourself with everything. Don't get me wrong, you still need to mediate a case. But then you're not taking it every step along the way. You're just setting aside a window of your time on a weekend, 3 or 4 hours, to sit down with a couple of people who are having a disagreement and try to help them work something out. And then whenever you're done, you're done. You don't have to worry about it anymore. So as a public service employee, I think that that's a pretty easy way to give back to the community without signing yourself up to an indefinite litigation.
I appreciate that. I just want to make sure that flexibility is there, and that for the person who wants to do this, that it's there and it's not arbitrary. And sometimes we get so focused on, oh, this AG is, he's all about it. But again, he's not always going to be in office. And so to make sure that the parameters that we put in place are there regardless of who the Attorney General happens to be. So to make sure that there's not someone else that comes in and says, well, no, I don't want you to do it just because I don't support this, believe it, want it, and I have the ability to say no. So that's what I was getting at. So with that, though, I don't see any additional questions. So I will go ahead and open it up in testimony for support of Senate Bill 37. So if there's anyone here in Carson City that would like to support Senate Bill 37?
Yes, that's me. Oh, it's on. Okay, I'm sorry. Thank you. I'm Harold Albright, and I'm the chairman of the board of the Neighborhood Mediation Center. We are the entity that provides free mediation services for people. I was on the Rose Commission many years ago when we tried to determine about alternative disputes resolution and whether that would be appropriate for Nevada, and we developed a procedure that's been codified and now used, well, since 1999, I think I guess. When I was elected Justice of the Peace, and I put it into our court in Reno. And basically, I'm here just to ask for your help. We're handling currently about 600 cases with the Reno Justice Court. We have a resolution of about 50% of those. 50% of those never come, most of those never come back to the court. Once the resolution is made, the parties are satisfied and happy, and very few came back to our court or come back to the court. We provide a 40-hour training service that trains mediators, and the importance of that is it takes the person and makes them a neutral. They don't come as advocates, and they don't come as judges. They come to help two people who are having a dispute. And our mission is to civilly resolve disputes in northern Nevada. So it's a broad concept where we help anybody, it's a rich man, poor man, beggar man, fools, all have disputes. And we help everybody. And in today's climate, if we can reduce some of the acrimony between people getting along and not getting along, we do that. And anyway, they come to us, a trained mediator helps them explore avenues to resolve this conflict themselves, and they reach their own resolution of it. And they, in court, we have restrictions of hearsay, we have restrictions of evidence, we have limitations on what we can do. We can generally find, damages or liability or whatever. Here, they can do anything the parties will agree to. And that's reduced in Reno Justice to a written agreement. And then we enter an order ordering them to comply with that agreement. And the few that have come back, our punitive sanction is to enter the judgment that was originally paid for by the complaint. So there's a penalty there, but it's been very, very seldom used. And this is a great process. We're going to approach the Sparks Justice Court. They're going to add about 100 cases to our caseload. We currently have 600. We provide training to the City of Reno, Reno Police Department, University of Nevada. We're just a great organization, but we need help. And to free up this pool of competent people to help us would be a real gift. So I urge you to do that, and I thank you for your time. Thank you. And I didn't say, Madam Chair and members of the committee, I'm sorry. Anyway,
You're fine.
okay, any questions?
Did you state your name and spell it for the record?
Oh, I didn't spell it. Harold Albright, Haroldalbright.
All right, thank you.
Thank you.
Is there anyone else in support of Senate Bill 37? Okay, broadcasting, will you open the lines? Is there anyone that would like to call in support of Senate Bill 37?
There are no callers at this time.
Thank you. Then I will open it up for anyone in opposition of Senate Bill 37, starting here in Carson City. Not seeing anyone. Broadcasting, is there anyone in the line?
There are no callers at this time.
Thank you. Then I will open it up for testimony in neutral of Senate Bill 37. Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Broadcasting, is there anyone on the line that would like to testify in neutral?
There are no callers at this time.
All right. With that, Mr. Holland, would you like to come and make any final remarks? Would you like to praise anyone else on the record?
Nathan Hall for the record. I would like to praise the entire AG's office. No, but seriously, I really do appreciate them giving me the opportunity to present this bill, and I appreciate you guys taking the time to listen to me, and I appreciate all of your questions. They were all fantastic. And Madam Assemblywoman, thank you for looking out for us. I didn't even consider that at all. So thank you for that. I'm really passionate about this, and I hope that you guys think that it's as good of an idea as I did. So with that, thank you very much for your time.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 37.
Thank you.
Our next hearing that we will have is Senate Bill 34. And this will be presented by General Counsel for the AG's office, Ms. Leslie Pirro. Ms. Pirro, are you with us?
Good morning, Madam Chairwoman. I am here.
Okay, we hear you. There you are. All right, we have you. So, excellent. So with Senate Bill 34, this measure revises provisions relating to legal representation in certain actions or proceedings. Ms. Pirro, we are ready whenever you are, so please proceed.
Good morning, members of the Assembly Judiciary Committee. I am Leslie Nino Pirro, General Counsel of the Attorney General's Office. You may recognize my last name. Yes, I am the other half of Team Pirro. And if he's giving you a hard time this session, please don't hold it against me.
He generally is, but we're not sure where he is right now. So I'm just reporting that to you, that he's not here in the room. So sure, he's downstairs in the lobby room watching and listening, and we'll both be getting texts soon. So please proceed.
A very brief reprieve for all of us. The Senate Bill 34 would make two needed changes to existing law. By first, explicitly authorizing an official attorney, either the Attorney General for the state or a chief legal officer of a political subdivision, to provide legal services to government employees when they are not a named defendant in a lawsuit. And second, conforming with related statutes allowing the Attorney General to determine that it is impracticable, uneconomical, or could constitute a conflict of interest for the Attorney General's office to serve as a legal advisor on a particular matter. Nevada law defines an official attorney as the Attorney General or chief legal officers of political subdivisions, such as a county district attorney or a city attorney. I'll use the term official attorney in explaining Section 1. Section 1 does a few things. First, it would authorize the official attorney to provide legal services to a government employee who is summoned or subpoenaed to appear in a legal action or proceeding, and then promptly request the official attorney's assistance. This section addresses a current statutory deficiency for situations when a government employee is not a named party in an action, but he or she receives a summons or subpoena for their testimony. So I'll give an example. The Attorney General's office has encountered this scenario when a highway patrol officer is subpoenaed for deposition testimony in a lawsuit between two private parties based on an accident report the trooper authored. The Attorney General's office seeks statutory authority to prepare the trooper to testify and then represent the trooper at the deposition, which will codify existing practice. Second, Section 1 will allow the official attorney to authorize legal services if they determine that representation is in the best interest of the state or the political subdivision. So I'll provide a general example. A plaintiff in a civil lawsuit can amend their complaint to name a government employee who provided deposition testimony. If the government employee seeks legal services before that deposition, the official attorney may examine the nature of the case and allegations and determine that providing legal advice before the deposition is in the best interest of the state or political subdivision. Finally, Section 1 provides a path for the official attorney to withdraw from the representation if the government employee employs their own counsel or the court authorizes the withdrawal. Section 1 also models existing law for defending government employees once they become defendants in a lawsuit by authorizing employment of special counsel under limited circumstances. Further, Section 1 makes clear that it does not change or diminish any existing immunity or legal protections. The Attorney General's office has one minor conceptual amendment to Section 1, which we will submit after the hearing. We'll amend Section 1, subsection 1, to reinstate the term state legislator at the request of the Legislative Council Bureau. Moving on to Section 2, which makes conforming changes to align with Section 1. That's it. Next, for Section 3, we submitted an amendment to reinstate Section 3 and remove the phrase "at any time prior to trial" from NRS 441.03375. This change is necessary because the Attorney General may need to employ special counsel for a range of civil matters that do not culminate in a trial, including the scenarios such as those described in Section 1. For example, the Attorney General's office has previously employed a collective bargaining attorney as special counsel to assist in negotiations when no Deputy Attorney General had experience in that highly specialized practice area. A collective bargaining negotiation is not a civil lawsuit, and it does not result in a trial. But special counsel was needed for a brief time following the 2019 enactment of collective bargaining statutes for state employees. So, second example, the Attorney General's office may identify a conflict of interest after a trial in the appellate stage. So removing the phrase "any time prior to trial" will give the Attorney General's office the flexibility required to meet the demands of modern law practice. So we ask that the phrase "at any time prior to trial" be removed from NRS 41.03375. Next, Section 4 harmonizes NRS 228.110 with other provisions of Nevada law regarding the Attorney General's decisions to employ special counsel. NRS 228.110 designates the Attorney General's office as legal counsel for all state matters arising in the executive department of the state government. The statute provides a single exception for when the Attorney General and his deputies are disqualified to act in such matter. Disqualification is a specific finding of fact and conclusion of law by a court. However, the Attorney General's office routinely provides legal advice to state agencies when no judicial proceeding exists. When there is no lawsuit, no judge is available to determine that the Attorney General's office is disqualified to act. This presents a problem. The only exception in the statute is unavailable when the Attorney General's office advises an agency outside of a judicial proceeding. However, other parts of Nevada law have demonstrated the appropriate solution. NRS 41.0339, 41.03435, and 228.091 authorize the Attorney General to independently decide when legal services are impracticable, uneconomical, or could constitute a conflict of interest, and then employ special counsel. Each special counsel contract is subject to the board examiner's approval process. These procedures ensure that state agencies receive timely, high-quality legal services. Section 4 seeks to add the same option to NRS 228.110, which will harmonize the statute with related Nevada law. I want to pause for a second to explain the terms impracticable and uneconomical. These terms were originally added to Nevada law in 1979. So adding this language to NRS 228.110 would not increase the Attorney General's authority. The terms do not address contracts for contingency counsel. Instead, this language facilitates the most efficient and effective client services to state agencies. As I noted, the Attorney General's office has employed special counsel in limited circumstances where no Deputy Attorney General has experience in highly specialized practice areas. Providing legal services under those circumstances is impracticable and uneconomical because learning an entirely new area of law would consume a substantial amount of time to the detriment of other state agency clients. Further, some state boards and commissions are billed at an hourly rate. So that means they would rack up pretty sizable legal bills before the real work even begins. And even if our deputy attorneys general could devote substantial time to learning that new area of law, that time might not be available due to pending litigation deadlines. The Attorney General's office has also employed special counsel when the state has active litigation in another state or a regulatory matter in Washington, D.C., because requiring a deputy attorney general to travel out of state to practice in a foreign jurisdiction is generally impracticable and uneconomical. Only a small number of deputy attorneys general have bar licenses in other states. And even if a deputy attorney general has an active bar license in the right jurisdiction, having a deputy undertake out-of-state practice could be detrimental to the state's interest because the deputy would not be a regular practitioner in that jurisdiction and might be unfamiliar with local rules and customs. Court rules may even require a local attorney to appear in a case, despite that deputy's local licensure. So, to meet state agency needs, the Attorney General's office negotiates favorable rates with special counsel and closely monitors the billing to ensure economical legal services. These contracts also provide long-term benefits to the state because deputy attorneys general work in partnership with special counsel. They acquire new knowledge and experience at a sustainable pace, which may eliminate the need to retain special counsel for future matters without negatively impacting other state agencies. Section 4 would conform NRS 228.110 to expressly authorize the Attorney General's office to employ special counsel in limited situations. These changes are in the best interest of the state. Moving on to Section 5, it speaks to enactment dates. Lastly, a friendly amendment will be presented by John McCormick from the Nevada Supreme Court Administrative Offices of the Court. And I want to thank you for your time and consideration on Senate Bill 34, and I am available to answer any questions you may have.
Thank you so much for that. And I appreciate your thorough explanation of impracticable and uneconomical because you knew those would have been very specific questions, but I think you gave us some real world examples and reasons for it. So now we understand that. So I really appreciate that. The first question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for your thorough explanation because I think it was very helpful. My question is similar to one that our chair asked on the last bill, which is, we won't always have the current Attorney General that we do have, and I know in Section 1 it leaves this determination up to the official attorney, and that could be a county or city attorney. I just want to know, what are some protections to ensure they don't decide not to represent someone because of a political reason or a personality conflict or some other issue?
So with Section 1, this is a little bit of a different consideration for either the state or the political subdivision, because this really is a legal determination on whether or not it makes sense for the government entity to provide representation at that stage. So I'd like to think that this is made with a very, with an eye to whether or not there may be any potential liability for the government entity down the line. So that with the, or in another example, the Attorney General's office had an investigator subpoenaed because there was her investigation. There was a civil lawsuit in which we did not end up filing criminal charges, and the gentleman who was investigated filed a lawsuit against the complainant. And they tried to use our investigator as a tool, as a weapon against the complainant. So that was one in which we had the one of our deputy attorney generals represent the investigator because we needed to protect investigative methods and law enforcement sources. So it was a little bit of a different consideration than liability for a government entity. But these are things I would like to think are not political considerations. These are truly protections of law enforcement considerations or potential liability. I don't think that they would be. I'd like to hope, there's no guarantee, but I would like to hope that they are not politicized.
Thank you for that. At this time, I don't see any additional questions, so I'm going to open it up for testimony in support of Senate Bill 34. If there's anyone here in Carson City that would like to testify.
Good morning, Chair, members of the committee. My name is John McCormick, John McCormick, Assistant Court Administrator at the Supreme Court, and I'm here to do two things today. First of all is support the bill. We particularly appreciate the codification of representation provided in Section 1. For example, one of the units I supervise at the court is our guardianship compliance unit, and oftentimes our investigators will get subpoenaed in sort of a related matter, and this just confirms the AG's current practice that we greatly appreciate of providing our staff that assistance. And then secondly, I'm here to propose an amendment.
Mr. McCormick,
Yes, ma'am.
according to the rules of our committee, if you are offering an amendment or any change to it, I would have to move your testimony to something else. So because the bill presenter has already mentioned that she's accepting a friendly amendment from you, I don't even think we're good.
I appreciate that, Chair.
Thank you.
Very much. Again, John McCormick for the record. And for the amendment, I would like everybody to step into the Wayback Machine with me and go back to 2013. Way back, when we created, when this body passed SJR 14 for a second time to put creation of a Court of Appeals on the ballot. There was enabling legislation for that, and it was sort of a ship passing in the night with another piece of legislation that put a number of these changes originally in Chapter 41, allowing the Attorney General's office to provide representation. And so those ships passing in the night resulted in the judges of the Court of Appeals not being included in the definition of a state judicial officer in NRS 41.03385. And so this amendment just includes those
But
judges.
We're not talking about the amendment.
Oh, sorry. Sorry.
But thank you for some background
All right.
information.
I'll shut up now.
I was not going to use that word either. I don't. Thank you so much. So you're in support. Thank you. Anyone else here in support of SB 34? All right, broadcasting, will you open the lines for anyone calling in support of SB 34?
There are no callers at this time.
Thank you. Is there anyone here in Carson City that would like to testify in opposition of Senate Bill 34? Not seeing anyone. Broadcasting, is there anyone on the line?
There are no callers at this time.
Thank you. Is there anyone here in Carson City that would like to testify in neutral of Senate Bill 34? Okay. Everyone in the room knows that they can reach out to members individually if they have additional comments. Is there anyone broadcasting on the line that would like to testify in neutral? All right, not seeing anyone?
There are no callers at this time.
Oh, thank you. No callers at this time. Thank you. Ms. Nino Piro, are you still with us?
Yes, I am here.
Okay, thank you. Would you like to make any final comments on the bill? Anything about an amendment or
No.
anything like that that needs to be on the record?
I think I'm good.
Okay, thank you. Then with that,
Thank you for your time.
Thank you for your presentation. With that, I will go ahead and close the hearing on Senate Bill 34. Our last item of business today is public comment. So we will be able to accept public comment on anything except for the two bills that we just heard. Is there anyone here in Carson City that would like to make public comment? Not seeing anyone. Broadcasting, would you open the lines? Is there anyone on the lines that would like to make public comment?
The public line is open and working, but there are no callers at this time.
Thank you. So with that, just a little information for everyone listening and planning on participating tomorrow. We are scheduled to start at 9 a.m. tomorrow. However, we have some other assembly business tomorrow morning, so it may be a little bit after 9. It will be 9-ish. And so that way, everyone just know it may be just 9-ish or 9:15-ish, something like that. But we will be back as soon as possible tomorrow morning, but we are scheduled for 9 a.m. With that, this meeting is adjourned, and I'll see you all tomorrow morning.